Well, thank you very much, Otto. As my predecessor, Thomas Mertens, already said, well, we did not discuss previously what we were going to say, and it's inevitable, given the topic, that we will overlap. But before you leave the room in disappointment, I can assure you that I do not agree on all points with the other speakers, and I'm going to highlight it from another perspective. So that might be give room to some further interesting discussion. Well, as a preparation for this short lecture, I reread, of course, parts of Hannah Arendt's famous account. And now Arendt has observed that she has both been severely attacked and praised for things and ideas which she actually never expressed or said. Well, that is the fate of a lot of writers, I guess, but this is specifically in the case of Hannah Arendt, it was very acute. I will focus on two aspects on which she has expressed strong opinions. First, what can or should be the contributions of criminal courts in the exposure of mass criminality? And secondly, what was exactly the foundation for Eichmann's guilt? Well, as Thomas Mertens already observed, Arendt was crystal clear on the proper functions of criminal courts in respect of system criminality. Courts had to assess the guilt or innocence of the man standing in the dock, and no more and no less. With obvious approval, she referred to the presiding judge, who told the Attorney General several times that we are not drawing pictures here, that there is an indictment, and this indictment is the framework for our trial. The implication was that courts should not indulge in providing sweeping historical records. Arendt told the courts to stick to their jobs. The purpose of the trial is to render justice and nothing else. Even the noblest of ulterior purposes, the making of a record of the Hitler regime which would withstand the test of history, can only detract from the law's main business, to weigh the charges brought against the accused, to render judgment, and to mete out due punishment. Arendt adduced practical reasons for her apprehensions. Judges were no historians. They lacked the proper conceptual and cognitive tools. Besides, as we all know, criminal court proceedings did not foster the appropriate context to build large narratives. However, for Arendt, it was primarily a matter of principle. From a sociological point of view, from a point of view of politics, it might be very interesting to investigate how the system functioned. From a moral and legal perspective, it was merely relevant why Eichmann had opted to join the system. Why did he choose to shift his profession as an expert in Jewish immigration to the architect of the final solution, causing endless misery to millions of innocent people? The emphasis on individual guilt serves to refute the infamous cock-in-the-machine doctrine, the efforts to blame the system and attribute individual action to the Führer, the Enlightenment, or original sin. In her later work, Responsibility and Judgment, Arendt emphatically held that in a courtroom there is no system on trial, no history or historical trend, no ism. Anti-Semitism, for instance, but a person, and if the defendant happens to be a functionary, he stands accused precisely because even a functionary is still a human being, and it is in this capacity that he stands trial. Moreover, the focus on individual responsibility aimed to dispel the morbid illusion of collective guilt. If all are guilty, no one is. It is a travesty that young Germans should feel guilty about sins of their ancestors. And I quote Arendt again, well, if young people in Germany, too young to have done anything at all, feel guilty, they are either wrong, confused, or they are playing intellectual games. There is no such thing as collective guilt or collective innocence. Guilt and innocence make sense only if applied to individuals. I must admit that I've wrestled a lot with Arendt's opinions on this topic, and I still have not completely come to terms with them. I must admit that I sympathize a great deal with her preference for individual guilt. It dovetails with my personal ideas and convictions. On the other hand, however, I think it is impossible to ignore the wider context. The structure of international criminal law itself forces us to take this context into account. Crimes against humanity require proof of a widespread or systematic attack which is triggered by a state or a state-like organization. System criminality presupposes interaction by planners, mid-level bureaucrats, and executors on the ground. And so does, for instance, a conceptual tool like joint criminal enterprise doctrine. International criminal law requires expansive theories of human agency and understanding of social dynamics. In order to capture the paramount importance, for instance, of Radio-Télévision de Mille Collines, in the triggering and organization of the genocide in Rwanda, the ISTR had to pay attention to the communicative capacities of transistor radios in rural society and to the linguistic and psychological content of certain expressions and lyrics. In short, since international criminal tribunals and courts are called to assess structural mass criminality, it is inevitable that they touch upon the broader historical context. Moreover, we should not forget that Arendt made her critical observations some 50 years ago. Richard Ashby Wilson has investigated the record of international criminal tribunals and has concluded that they have performed well compared to domestic criminal courts, probably because they are more detached and have succeeded in maintaining their impartiality. But international criminal tribunals also have access to more resources, and therefore they have been able to improve their techniques of investigation. Ashby Wilson has described how the judges of the ISTY, not privy to the political and historical background of the former Yugoslavia, invited scholars in history as expert witnesses in order to familiarize themselves with that background. And it is probable that this procedure has contributed to the high quality of the historical record and has increased the tribunal's moral authority as an example of historical impartiality. In this respect, one might point at the first judgments of the ISTY and the ISTR, like the Akayeshu and the Tadic case, which started with a rather extensive survey of the historical background of the respective conflicts. The second aspect which I would like to discuss is the content of Eichmann's guilt. What reproach did actually Arendt make to Eichmann? Well, as is well known, she blamed him for his sheer thoughtlessness. The gist of the banality of evil was that he merely never realized what he was doing. Now, from a criminal law point of view, this is not so spectacular. The fact that we translate mens rea by guilty mind obfuscates the idea that criminal law does not require the perpetrator to possess intent on wrongdoing. In that sense, motives are immaterial for criminal law, although they may be relevant for sentencing purposes. The effect and novelty of Arendt's findings was more of a psychological nature. It was shocking to learn that the flat psychology of Eichmann was so incommensurate to the heinousness of his crimes. His lack of reflection did not absolve Eichmann from reproach and blame, but, to the contrary, became the very foundation of his guilt. Of course, Eichmann tried to refute this accusation by contending that nearly everyone in his surroundings agreed with the politics and principles of National Socialism. Why was he held responsible when he acted in conformity with the prevailing laws and morals? Neither the Israeli courts nor Arendt accepted this excuse. As Alet Smeulers and Wouter Werner comment, For Arendt, the fact that Eichmann operated in a political, moral and administrative context that had normalized mass killings did not lift his personal responsibility. I tend to agree with that point of view, but it does not release us from the obligation to ponder on the question what it means to live in a moral universe where the tables are turned. In my opinion, the Israeli court could interpret and subsequently dismiss Eichmann's defense as a mistake of law because of the limited intelligence of the accused. Eichmann made some clumsy efforts to refer to a higher natural law of historical necessity which required the final solution, but the inconsistencies in his presentations made it relatively easy for the judges to refute them. Eichmann had been deeply flawed in assuming that the Führer's will and vision of a 1,000-year empire were superior to any cocktail of law and morals. But this preposterous mistake could not excuse him, as he should have known better. But I wonder whether the courts would have such an easy time if they would have been confronted with Hitler or Nietzsche, standing trial in the dock. Let us take the latter, Nietzsche. I am sure that he would say, "Well, gentlemen and ladies, you may convict me to the severest sentences, but I beseech you not to acquit me on account of mistake of law, because that would be an insult to my intellect. I contest and challenge everything that you hold dear, because your moral universe is completely different from mine." Ever since Eichmann, international criminal tribunals have indeed been faced with more intelligent, or at least more determined and radical accused. Tadic, Milosevic and Taylor challenged the jurisdiction of the tribunal which was about to try them. It was not only a procedural or institutional issue, these challenges profoundly aimed at the roots of the legitimacy of the international community to impose a moral order which condemned those crimes which strike at the core of humanity. In my view, there is no other option for international criminal tribunals than to reaffirm and reconstitute their fundamental right to judge those who trample that order in the extreme. And the last 20 years, international tribunals had to solve legal issues which were more difficult than those posed by the Eichmann trial. However, I think that Eichmann served as a dress rehearsal and paved the way for these more recent and intricate proceedings. I thank you for your attention.